Good afternoon. It is Wednesday, March 26th, 2025. The Senate Judiciary Committee will come to order. We do have a quorum present, and know that the agenda might move around a little bit, but we are going to start with you, Senator Kupec, with Senate File 1706. When you're ready.
I am ready. Thank you, Madam Chair. Thank you, members of the committee. It's great to be back after such a long time away from you. This is Senate File 1706. It is a small but important technical fix to make sure that Minnesota vets and their families receive benefits and services in the most streamlined way. This bill will allow the Minnesota Department of Veteran Affairs staff working in the Veteran Stable Housing Initiative to access the Department of Children, Youth, and Family Services Maxis database. Having access to that data streamlines the process to verify eligibility and complete entry of veterans. MDVA staff will only have read-only access to the database, so they can't alter anything, and only select staff at MDVA will have the access to it. This is a common sense change to help Minnesota get and to maintain functional zero for veterans homelessness. MDVA has worked with DCYF on this bill, and they are fully in support of the changes. So with that, Madam Chair, I have a testifier here if they need to, or answer questions, or however you would like to proceed.
Thank you, Senator Kupec. I know you've got testifiers here if we have questions, so we'll just see if the committee has questions now and go to discussion. Okay. Well, seeing none, this bill is being laid over. All right. Any final comments on your end?
No, thank you.
Okay. Thank you, Senator Kupec. Senate File 1706 is laid over.
Madam Chair. Madam Chair.
Senator Westrom.
Just want to let him know not to get used to this.
We're going to move to Senate File 2120. Senator Seeberger, when you're ready.
Thank you, Madam Chair. Happy to be here to talk about Senate File 2120. This bill speaks to the community supervision appropriation, and instead of taking up a lot of the chair's time, I think I'll turn it over to my testifiers. I have Emilio Lamba with the Association of Minnesota Counties, and I have Carla Bingham, who is unknown around these parts, brand new.
Unknown, parts
freshly
unknown.
here in the Capitol.
Thank you. Appreciate you saving us some time. Emilio Lamba, when you're ready.
Thank you, Madam Chair, and members of the committee. My name is Emilio Lamba, and I serve as the Public Safety Policy Analyst for the Association of Minnesota Counties, as well as the Legislative Director for the Minnesota Association of Community Corrections Act Counties. First, I want to express my appreciation to this committee and the Minnesota State Legislature for your ongoing commitment to community supervision. Your support ensures that the roughly 95,000 individuals under supervision in our state receive the supervision and resources necessary to successfully reintegrate into their communities. While others today will speak to the successes of the revised funding formula and the need for both full funding and a 3-year averaging, I wanted to use my testimony to provide additional context to the key provisions in Senate File 2120. The bill first proposes incorporating a 3-year average of the most recent probation data into the community supervision formula under State Statute 40110. As many of you know, our counties operate on a different fiscal calendar start than the state of Minnesota, meaning that they will set their budgets oftentimes before the state and their budgets for their community supervision departments. This misalignment creates financial uncertainty, often forcing counties to reduce staff, increase caseloads, or cut essential programming, undermining our shared goal of good public safety. Implementing a 3-year average is a cost-neutral solution that smooths funding fluctuations and has the support of all 3 delivery systems in the state, including the Community Corrections Act counties, county probation officers, and the state and the Minnesota Department of Corrections. Lastly, Senate File 2120 also seeks full funding of our community supervision formula to ensure that core supervision services across Minnesota are adequately resourced as outlined in the Minnesota State Statute 40110. Stable funding is critical to delivering evidence-based, responsive supervision that provides individuals with the tools and support necessary to successfully reintegrate and avoid recidivism. Without full funding, counties face mounting challenges that could result in costly impacts both to the communities in the state as well as the clients that we serve. Thank you for your time and the opportunity to testify on Senate File 2120. I'm willing to stand for any questions following.
Thank you, and we'll move to Commissioner Carla Bigham.
Thank you, Madam Chair, and members of the committee. I'm Washington County Commissioner Carla Bigham, and I am here on behalf of the Association of Minnesota Counties today to highlight why full funding for the community supervision formula and the implementing of the 3-year averaging are essential for counties across the state. As a former legislator and county commissioner, I've seen firsthand how policy decisions at the Capitol directly affect counties' ability to provide effective community supervision. Public safety does not start or end with incarceration. Counties are responsible for ensuring individuals successfully transition back into the community with the resources and accountability necessary to reduce recidivism. The importance of stable, well-funded supervision cannot be overstated. Research has consistently shown that when probation officers have time and resources to engage meaningfully with individuals, outcomes improve. Stable funding allows counties to implement proven interventions like cognitive behavior therapy, substance use treatment, and employment assistance, programs that help people stay on track and reduce the likelihood of reoffending. However, when supervision services are underfunded, counties are forced to make difficult decisions, whether that's increasing caseloads, cutting essential programs, or delaying hiring. These gaps in services don't just impact individuals on probation, they create a ripple effect across the entire criminal justice system. When supervision fails, revocations increase, placing additional strains on jails, courts, and correctional facilities. Investing in supervision is a proactive and cost-effective approach to public safety. We cannot ignore the impact of the Minnesota Rehabilitation and Reinvestment Act, otherwise known as the MRRA. The goal of the MRRA is to reduce incarceration by expanding earned release opportunities, meaning more individuals will be transitioning from prison to supervision. Counties are willing to work to ensure successful implementation of the MRRA, but that is only possible if we ensure counties have the resources to provide effective reentry support. Counties have worked hard to implement evidence-based practices, prioritize rehabilitation, and enhance public safety. Continued partnership with the state is essential to sustaining these efforts. Senate File 2120 provides the support needed to ensure community supervision remains effective, stable, and responsive to the needs of our justice system. I urge your support of Senate File 2120 to fully fund and stabilize community supervision services in Minnesota. I thank Senator Seeberger for her unwavering support. I thank this committee. Thank you, Madam Chair, and I'm happy to stand by for any questions.
Thank you. Senator Seeberger?
Madam Chair, I do have an A1 authors amendment. I'd like to move it this time.
Yes. It looks like there's the A1 amendment that could be incorporated into the A2 amendment.
Well, I'd like to offer them separately if I could, Madam Chair.
Okay.
I would like to offer the A1 as an authors amendment, please.
Sounds good. So Senator Seeberger offers the A1 amendment. It's an author's amendment, so all those in favor, say aye. Aye.
Aye.
Okay, the amendment is adopted. And then Senator Seeberger, do you want to discuss the A2 amendment?
Happy to discuss the A2 amendment, Madam Chair. Madam Chair and members, the A2 amendment is before you to start the discussion. It was brought to me by MACPO, the Minnesota County Probation Officers. And while we've made great strides in our last biennium in our efforts to reshape the formula and provide as many resources as we could, we also made a commitment to fully fund the formula in the future. And this led to the decision to delay the fee sunset. We wanted to give ample time for counties to gear up and to implement the new formula. It was important to legislators to see a future where we aren't charging those who need the services for the services. And all that is to say, if the bill is fully funded, then there's no need for this amendment. But if not, then we need to have a serious discussion about delaying the fee. I have with me today Mike McEwen, a probation officer who is able to speak on behalf of MACPO to give the committee more perspective on the issue.
Thank you. And just begin your testimony by introducing yourself.
Mike McEwen, Director, Wright County Court Services, Buffalo, Minnesota. Okay. Senator Seeberger, Chair and Committee. This is a pivotal time. I'm going to kind of go off the cuff a little bit, but 2 years ago, the last biennium, I think there was huge strides that were made to support funding, as you've heard earlier. But that being said, and I'll talk about Wright County for a second, if it doesn't go through, the current funding that's been proposed, our county alone will, over the next biennium, lose about $500,000. If the amendment on fees, in addition to that, you're going to have to add another $215,000 per year for our county alone. So now we're clipping towards $1 million loss. So clearly I'm in support of both. But if the one doesn't go, we need this amendment to basically stay afloat, providing the continued services that we've have become accustomed to. And we're a leader in evidence-based practices. We're a leader in the area. We love what happened the last biennium. It's fit our needs. It's helped propel our profession and our agents and our departments to do the best work possible for our clients so they don't end up in prison. But without a funding source, it will be drastic. I've been around long enough in the late to mid-90s when we passed Caseload Reduction Act. Same thing happened then. Funding stopped, and we ended up in an unbelievable shortfall that you heard about last biennium. So clearly support the amendment and also the bill. Thank you.
Thank you. Appreciate the explanation. And anything you want to add, Commissioner Bigham?
Thank you, Madam Chair. We're interested in the amendment. The 3-year average is a priority, but I agree with the testimony. I mean, if we're fully funded, there is no need for the delay, and without the full funding, that leaves a hole, as was testified to in the funding because of these fees. So,
Any questions on the A2 amendment? Okay.
Madam Chair,
Yes, Senator Seeberger.
I brought this amendment forward to begin the discussion and to stress the importance of fully funding this program. As you've heard, if it's not fully funded, our counties are going to be in a situation that's not sustainable. I trust the committee has heard the importance of the need for this funding. So at this point, I'm going to withdraw the A2 amendment.
Okay, thank you. Appreciate the discussion, Senator Seeberger. So you've withdrawn the A2 amendment. I'll go to member questions in a moment, and just want to know I have one more testifier that we will bring forward and we'll continue discussion. Nikki Niles, if you can come forward.
You're fine.
Thank you, Madam Chair, members of the committee, for the opportunity to testify in support of Senate File 2120. My name is Nikki Niles, and I proudly serve as the Community Corrections Director for Dodge and Olmsted County and as a co-chair for the Legislative Committee for the Minnesota Association of Community Correction Act Counties. Our association represents counties that have elected to administer all community supervision and reentry services in their respective jurisdictions, ensuring public safety through effective supervision, rehabilitation, and reintegration efforts. Community supervision is a core function of our justice system and a cost-effective alternative to incarceration. In 2023, of the roughly 102,000 individuals that were incarcerated on probation or supervised release, 92% of them were on probation. Community supervision provides accountability where supporting individuals with the tools they need to be successful in the community. We want to thank the legislators' establishment of the revised community supervision formula, which has eliminated funding disparities and better equipped our state to deliver the core services of supervision. Senate File 2120 addresses this by fully funding the community supervision formula and implementing a 3-year averaging model. This approach allows counties to plan effectively, maintain staffing levels, and invest in evidence-based practices that improve public safety outcomes. Without predictable funding, counties are forced to make difficult choices that can undermine long-term supervision strategies and program effectiveness. As others have stated, adequate resourcing is also necessary for the successful implementation of the Minnesota Rehabilitation and Reinvestment Act, otherwise known as MRRA. Increased supervision demands require appropriate investment to ensure that we can meet expectations while maintaining public safety and providing essential support services. By ensuring stable and adequate funding, we can work together to support effective supervision, enhance public safety, and provide the necessary resources for long-term success. We ask that you support Senate File 2120 and its passage in order to sustain and strengthen community supervision across Minnesota. Thank you for your time and consideration. I am happy to answer any questions.
All right, thank you for your testimony. We'll move to the member discussion. Senator Limmer?
Thank you, Madam Chair. Senator Seeberger, you're relatively new to the committee and you're a good member. But I've had a lot of discussion over the years about the probation services, how they mix with corrections department and how they mix with the two servers that produce the service for probation across the state. Recently, the administration through the Department of Corrections has basically said they want to take over the funding. They want to take over probation in the state of Minnesota, much to the chagrin of local services. And I'm not sure if there's going to be enough money in the system this year. I'm not even sure if the administration can produce that kind of a priority from state of Minnesota. I certainly appreciated the local efforts that we've relied on in the past, although despite a state law that guaranteed the state to produce 50% of the probation cost, they have not delivered. So now we're in kind of a new direction, and I know this is stuff that you know, but I'm just kind of venting my frustration. This is supposed to have been covered. This is supposed to help counties alleviate their budget issues that are caused by the lack of support from the state. And I was disappointed that you withdrew the A2 amendment. Counties certainly need the time to try and figure out how to get this resolved. And, it states in this provision, each probation agency must provide to the commissioner a written plan for phasing out supervision fees for individuals. And then that plan has to be given by a specific date in 27, but I think your offer to give the timeline 2 more years is exactly what we need. So I'm not going to push the amendment, but there is support on our side of the aisle for doing this. Just wanted to give you a signal on that.
Okay, we're just gonna move to Mr. Turner.
Thank you, Madam Chair and members. I spoke to Senator Seeberger about this previously. In order for the bill to reflect full funding, we need to add the following, and I'll make it as an oral amendment. Page 3, line 13, delete the is and insert and $12,662,000 in fiscal year 2027 are. And then that would be full funding both years, and it would be tucked into the base of the department.
Madam Chair, could Mr.
Mr.
Turner reread his amendment, please?
Yes.
Thank you.
Yes, Senator Anderson. Mr. Turner.
Madam Chair, members, page 3, line 13, delete is and insert and $12,662,000 in fiscal year 2027 are.
Senator Seeberger.
Thank you, Madam Chair. Yes, we did discuss this amendment, and it is an appropriate amendment. I would move that amendment.
All right, Senator Seeberger moves the amendment as described by council, by fiscal. All those in favor, say aye. Aye. Okay, that amendment is adopted. Any other questions? Okay, any final comments, Senator Seeberger?
Madam Chair, as we know, without full funding, the gains made by counties are at risk. And with some counties facing financial instability, a potential outcome that could eliminate tailored community-based programming. Without full funding, Minnesota can provide the adequate level of base supervision. With full funding, Minnesota can provide the adequate level of base supervision services as well as practices that are known to improve public safety at a cost lower than that of incarceration. I urge the committee's support of Senate File 2120.
All right, thank you, Senator Seeberger. Senate File 2120 is amended, is laid over, and we're going to move to your next bill, Senate File 2291. When you're ready, Senator Seeberger.
Thank you, Madam Chair. It is my pleasure to present to the committee Senate File 2291. This bill was brought to me by the Minnesota County Attorneys Association. Since the early 1980s, MCAA has received a biannual legislative appropriation designated for prosecutor training, which has allowed MCAA to train thousands of prosecutors and has provided in excess of 950 live accredited classes. This grant is currently housed in the Department of Public Safety in the Office of Justice Programs and is funded at $100,000 per year through 2025. This bill requests an increase of $25,000 for an annual total of $125,000 to offset the rising costs of putting on these educational programs and the increase of topics needed to cover. You have a handout in your packet that outlines how the funds are used. There's an annual report, and I have Bob Small, Executive Director of the Minnesota County Attorneys Association, here with me today to share more details on the importance of these funds.
Thank you. Bob Small.
Madam Chair, members of the committee, my name is Robert Small, and I am the Executive Director for the County Attorneys Association. I want to thank you for hearing Senate File 2291. I want to thank Senator Seeberger for bringing this forward. This is a priority issue for our association. As you know, part of our mission is to provide training and continuing education for our county attorneys and our assistant county attorneys, as well as our law enforcement partners. The past appropriations from the legislature has been instrumental in allowing us to accomplish that mission, and we're very thankful for your past support. The bill before you, as Senator Seeberger mentioned, would provide $125,000 per year for this critical training. To give you a sense and scope of training that we provide, we're able to provide all of our county attorneys and assistant county attorneys throughout the state the opportunity to earn enough continuing legal education hours each year to meet their mandatory reporting requirements. These opportunities also demonstrate the importance MCAA's economical training provides to statewide county attorneys and their assistants. Our reach is meaningful training that deals with the day-to-day operations that county attorneys face. Indeed, 67% of our training is attended by attorneys from our greater Minnesota. The $125,000 for each year, I was just going to give you a sample of some of the courses. We have an annual trial school for newer assistant county attorneys and county attorneys, but we also have added a new advanced trial school for our more seasoned assistants. The cost of updating various manuals also will be funded by this grant. Some examples of our training just from our upcoming training calendar include courses on prosecuting human trafficking cases, new training for civil and new prosecutors. We have a series of prosecutions on DWI training, including prosecuting the drug driver, driving under hallucinogens, and DWIs with dissociative anesthetics. We have a course coming up on trauma-informed approaches when dealing with victims, as well as a course on investigating and prosecuting a sexual assault case where the victim is a male. Each session, as you go about your job of passing laws, we go about our job of informing and training our prosecutors on these new laws. So as long as you continue doing your job, the need for us to continue to do our job rises. At the end of the day, well-trained prosecutors result in more timely and fair resolution of cases and fewer appeals. We will continue to strive to provide critically important training and sincerely hope that you will help us achieve this goal with additional funding. Thank you very much for hearing me, and I will stand for any questions.
Thank you. Members, are there any questions? All right, seeing none, this bill is also being laid over. And thank you, Senator Seeberger. So we are laying over Senate File 2291, and we're going to move, we'll move to House File 124, Senator Duckworth.
Well, thank you, Madam Chair. I greatly appreciate it, and I will have to rely on a friend to move the A1 amendment for this bill, if you'll allow it.
Thank you, Senator Duckworth. Senator Seeberger moves the A1 amendment. Is there any discussion? Okay, all those in favor of the A1 amendment, say aye. Aye. The A1 amendment is adopted to your bill as amended. Senator Duckworth.
Thank you, Madam Chair. And first, I'd like to begin by thanking Senator Latz, as well as all the staff members that played a role in developing the amendment and adding some input and good feedback to it. It's a result of the conversation we had a couple of weeks ago in this committee. And what this amendment does is add some guardrails, transparency, and reporting requirements to the situation in which a law enforcement officer might be killed in the line of duty, and then members of the community want to make monetary donations to that city so that the city can then use those donations on behalf of the family or memorial services for a first responder should they find themselves killed in the line of duty. So again, my thanks to everybody who helped us with the amendment, and I'm hoping that we can continue to move the bill swiftly along so it can help our friends in Burnsville and their upcoming memorial service in the month of May. Thank you.
Senator Latz.
Thank you, Madam Chair. Thank you to Senator Duckworth for being willing to work on this one. The main concern we identified before was the potential that someone could make a contribution directly to an individual police officer, claim it was in honor of the deceased officer without any reporting requirements, without any disclosures, without any limitations or anything like that, and no one would know about it, which opens up potential anyway for all sorts of improper use of funds going to account. So this amendment closes that door completely and tightens up the language so that any contributions go to the agencies have obligations to report, to comply with their own requirements, and so the public as well. So basically, the potential for abuse is substantially minimized under the public accountability of these agencies. So I think this is a much better approach, and I appreciate Senator Duckworth doing that. And even though I had the mic off, I'm hoping the recording picked it up, and I'm not going to repeat what I said.
I almost did the same thing. Thank you, Senator Latz. Yeah, I know there was a lot of work that was put in to just make sure those guardrails are in place, and appreciated you sharing that, Senator Duckworth, as well as you, Senator Latz. Is there any other discussion about the bill? Okay. All right. Well, this bill is then headed to the Senate floor. So I will say Senator Latz moves House File 124 as amended, be recommended to pass and referred to the Senate floor. All those in favor say aye. Aye. Okay. This bill is on its way to the Senate floor, and thank you, Senator Duckworth.
Thank you all. Appreciate it.
All right, Senator McEwen, you can come forward. We're going to take up Senate File 2373. And when you're ready, you can begin.
Thank you very much, Madam Chair and committee members. I appreciate very much the opportunity to present Senate File 2373, the governor's proposed budget for the Labor Committee this year. I will note that you have the first engrossment before you. We amended the portion of the DLI policy bill within Judiciary's jurisdiction into this bill. I would be happy to summarize the provisions within the Judiciary Committee's jurisdiction or the whole bill, whichever you would prefer.
Senator McEwen, if you could just give us a brief description of the whole bill so we can understand the context, and then we'll focus on the provisions within our jurisdiction.
Very good. Thank you very much, Mr. Chair. Article 1 is the appropriations. The budget proposal maintains base funding and adds modest operating adjustments for the Department of Labor and Industry, Bureau of Mediation Services, Public Employment Relations Board, and the Workers' Compensation Court of Appeals. It proposes new funding to the Labor Standards Division to enforce the existing misclassification laws within 2.5 FTEs. It includes $5 million in the first year and $2 million in the second from the Workforce Development Fund to support the establishment of a statewide registered teacher apprenticeship program and joint apprenticeship training committee. And it extends the availability of the funding for the report on single stairways for apartment buildings through the report's due date in June 2026. Article 2 in Section 1, lines 7.15 through 7.23, the language from the DLI is the language from the DLI policy proposal, which would allow DLI to apply for an order enjoining and restraining violations of employment laws under DLI's jurisdiction. This would be a provision within this committee's jurisdiction. It also contains language on the proposed construction code and licensing fee adjustments to align with increased expense and inflation, since many of these fees have not been adjusted since back in 2005 to 2013. There are many letters of support for this proposal, in particular the construction code adjustments from in both industry and labor groups that I would be happy also to send the committee if you're interested in that building code fee section and the adjustment provisions. Also in Article 2, make some construction code policy changes that we could hear some more about from the commissioner in testimony. Then Article 3 contains the governor's budget proposal to clarify employees' rights and employers' obligations under existing laws and enact remedies for workers who are not allowed to take their breaks. Minnesota is one of few states that does not have a clear standard in statute addressing the amount of break time that must be provided to employees during the workday. This proposal would ensure employees are entitled to at least 15 minutes of rest break time for every 4 consecutive hours worked and at least a 30-minute meal break for every 6 consecutive hours worked. This proposal also reduces the amount of consecutive time that must be worked before a meal period is provided from 8 hours to 6 hours to align with the minimum standards provided in many other states. North Dakota requires a meal break that is provided in a 5-hour shift as an example of what a neighboring state has. Thank you very much for your time and consideration, and when the chair is ready, I would turn it over to Commissioner Nicole Blissenbach to add some remarks about the bill, and I respectfully ask for your support.
Thank you, Commissioner. Come on forward. Go ahead and present your testimony, Commissioner.
Thank you, Chair Latz and members of the committee. I'm glad to be back here this year. My name is Nicole Blissenbach. I'm the Commissioner of the Minnesota Department of Labor and Industry. I'm here to testify in support of Senate File 2373, the department's budget bill. Within this committee's jurisdiction, I would like to specifically highlight my support for the temporary restraining order provision found in Article 2, Section 1, as well as the break law provision found in Article 3 of the bill. The provision in Article 2, Section 1 establishes authority for the Department of Labor and Industry to apply in district court for an order restraining an employer from violations of employment laws under the department's jurisdiction. If issued by the district court, this temporary restraining order would require an employer to come into compliance with the law in question. Some violations, including certain provisions of the Women's Economic Security Act and anti-retaliation statutes, are so time-sensitive that irreparable damage may be done to the employee by the time a compliance order is issued and a case proceeds through the administrative contested case process. For example, if a pregnant worker were being denied accommodations under the pregnancy accommodation law, by the time the contested case process were complete, the pregnant worker will have given birth and the window to guarantee rights to pregnancy accommodations would be gone. A court order restraining the violation would allow the department to intervene quickly and help ensure that timely pregnancy accommodations are provided. Article 3 of the bill establishes clear rest and meal break periods in state law. Many employers and employees are surprised to find that the length of a rest break and meal break is not clearly defined in state law. This provision would require at least 15 minutes of a rest break for every 4 hours worked and 30 minutes for a meal break for every 6 hours worked, and includes the damages and penalty structure for violations that bring that provision into this committee's jurisdiction. The employer would be liable to the employee for the rest and meal break time that should have been provided, plus an additional amount as liquidated damages. DLI would be able to assess a penalty of up to $1,000 for each violation when rest and meal breaks are not provided. Any penalty collected goes to the general fund. Thank you for the opportunity to testify in support of Senate File 2373, and I can remain for any questions.
Thank you, Commissioner Blissenbach. I'm told that Mark Bruner also wishes to present some testimony. Mr. Bruner, come on forward, and then we'll have committee discussion. Mr. Bruner, please keep your comments focused on the provisions within the jurisdiction of this committee.
Thank you, Mr. Chair. Mark Bruner, Manufactured Modular Home Association of Minnesota. We represent builders of manufactured modular homes, about 14 plants in the state, as well as the state's nearly 1,000 privately owned manufactured home communities, which are home to about 50,000 homes in the state. Our 85% of new homes manufactured are sited on private property in the state. The remainder go on leased land in the manufactured home community, which sometimes is not understood in terms of today's manufactured homes versus, many years ago when most were personal property or chattel. We've been working with the department prior to the bill being formally introduced. We've come to some agreement on several points, so I will just address a couple. And actually, we do have some agreement on these, but because they're in front of you as a part of the bill, just wanted to put our concerns on the record.
Mr. Bruner, we're only going to hear the concerns related to the provisions within this committee's jurisdiction. So that is Article 2, Section 1, and Article 3. Any other public record you'd like to make will have to happen some other place, sir.
I understand, Mr. Chairman.
Thank you.
So under Article 2, subdivision 25, the shipment fee label.
I'm sorry, that does not within this committee's jurisdiction. The only provision in Article 2 within this committee's jurisdiction is Section 1, line 7.15 to 7.23, dealing with civil actions. Do you have any information you'd like to share with us on that provision, sir?
I do not, Mr. Chairman.
All right. Do you have any information you'd like to share with us with regard to Article 3, the meal break remedies?
I do not.
Thank you. Mr. Bruner, I'm afraid we don't have time to hear any other testimony in connection with this bill.
All right. Thank you.
All right. Thank you, sir. Is there any committee discussion with regard to Senate File 2373 regarding the provisions before this committee? Senator Limmer.
Thank you, Mr. Chair. Mr. Chair, could you tell me, there was a reference to a $1,000 fine per day per employee. Is that in our jurisdiction?
Ms. Primo.
Mr. Chair and members, yes, those provisions are in Article 3, specifically page 47, line 22, and page 48, line 8.
Senator Limmer.
Thank you, Mr. Chair. Senator McEwen, how did you arrive at the $1,000 fine? Is this for missing or not allowing a worker to have a lunch break? Maybe you could answer that question for me first.
Or Commissioner Blissenbach, whoever prefers to answer.
Thank you. Thank you, Mr. Chair, and thank you for that question, Senator Limmer. I will go ahead and defer to the commissioner who is involved in that determination.
Commissioner Blissenbach.
Thank you, Chair and Senator. That is it's in line with much of our authority for penalties for many of the laws that we enforce at the department. They are typically per violation, and when it comes to meal and rest breaks, per violation would be a failure to provide an employee with the rest break required by law or the meal break required by law.
Mr. Chair.
Senator Limmer.
Is there logic to a $1,000 fine? How did the department ever arrive at that? To me, it seems excessive. It doesn't seem proportional to missing a lunch break. So maybe you could give me a little background on how the department arrives at that.
Commissioner Blissenbach.
Thank you, Chair and Senator. There's a lot that goes into the determinations, but like I said, we look to other penalty authority that we have in law. I will say it is up to $1,000. We are required to use certain factors. Whenever we have discretion for issuing a penalty, we are required to use the factors that are outlined in state law, things like gravity of the offense, size of the business, number of employees affected, before we come to a conclusion as to what appropriate penalty would be in the situation.
All right. Thank you, Mr. Chair.
Senator Cruin.
Thank you, Mr. Chair. And so I take it, and looking at the statutes that this Article 3 is referencing, that this applies to every employer, no matter how many employees they employ, no matter how big they are, no matter how much their revenue is, no matter whether the employee is part-time or full-time. This is across the board applying to every employer or employee in the state of Minnesota. Do I have that right?
Commissioner Blissenbach.
Chair and Senator, yes, that is correct.
Mr. Chair?
Senator Croom.
Thank you, Mr. Chair. And then, has there ever been any thought by the bill author about first-time offenses being exempt from a $1,000 fine? Does it have to be the very first one? We have a lot of small businesses in this state that I don't know how small businesses are going to continue. I mean, just the amount, I won't get into that, but this seems incredibly excessive to the smallest of our businesses who don't pay attention to anything what's going on here at the legislature. They're too busy working and providing a living for their families. But has there been any thought about only applying this very steep penalty to repeat offenders?
Senator McEwen.
Thank you, Mr. Chair, and thank you for that question, Senator. I'll also defer here to the commissioner, but my sense is, as the commissioner had stated, that this is a maximum amount, that is, it's up to 1,000. And I know in many areas of what the department does, and we've heard their testimony multiple times in the Labor Committee, they do intensely work with businesses as partners to try to help them be in compliance. And I don't necessarily even think there's a lot of discretion there, and then applying those factors, they would come to a decision about what was the appropriate penalty. But the commissioner, I think, can perhaps add to that.
Commissioner Blissenbach.
Thank you, Chair and Senator. That's absolutely correct. Our first goal when we are contacted with a complaint is to use our inform and educate process to bring employers into compliance without any type of action, because we have limited resources, as does everyone here. And so our goal is to bring people into compliance without issuing any penalties. If we do get to a point where we are issuing penalties, we consider all of those factors to come to an appropriate remedy or an appropriate penalty under the circumstances. One of those is past history of violations. That is one factor we have to consider when coming to the remedy or the penalty that we are issuing.
Senator Croom.
Thank you, Mr. Chair, and I appreciate that, except we're writing into statute now. It's not what this administration does or what current practice is. I mean, the law is the law, and I don't see anything in the law that would prohibit this administration or a future administration from going straight to a fine, foregoing the educational component. And it says up to 1,000. I don't see anything that would prohibit an administration from going straight to a $1,000 fine on the very first offense. And you combine that with the $1,000 fine, which is incredibly excessive, it seems to me. You know, it's setting up a pretty dangerous situation for our small businesses. But you know, those are just my comments on this. I think it's increasingly becoming a more difficult state here in Minnesota to be a small business owner. And I think this is just going to make it more difficult. And I think this is incredibly punitive to start talking about a $1,000 fine per instance for, you know, if they make even a minor mistake on a 15-minute work break. I mean, the way I read this, it could be a 10-minute instead of a 15-minute, and they get a $1,000 fine if that can be documented. And I just think this is way too punitive.
Commissioner Blissenbach, if a worker had already taken, if a worker wants to go to the bathroom, does this 15-minute break, is that part of what that's intended for?
Yes, Chair, that is correct.
So honestly, I'll tell you, I've got more confidence in our public servants than to rush straight to a full fine of $1,000 for this. But if someone's working 4 hours straight and their employer's not giving them 15 minutes to go to the bathroom, they deserve whatever penalty is allowed for in law. And if an employee is working 6 hours straight without a break to eat a meal, and their employer won't let them take a break to eat a meal and says, you got to work straight through until this work is done at 8 hours or whatever it is at the end of the day, that employer deserves to be penalized $1,000, if you ask me. It's actually inhumane to deny workers the right to go to the bathroom or to have a little break after 4 hours or in 4 hours or to eat a meal. And every employer should be on notice that they've got to do that. And there are going to be substantial penalties if they intentionally, willingly, or even negligently fail to do so. And frankly, the potential fine is got to be enough to make it hurt if they're going to violate the law. It doesn't mean that's what they're going to get penalized in each particular time. But a company that's, $1,000 in the scheme of a lot of companies, it's got to hurt enough that it's not going to be worth it for them to ignore the law and take the chance that someone's going to go complain, especially if complaining might cost them their job as a practical matter too. So I'm all for keeping a substantial incentive in there. I think $1,000, frankly, is probably a bit light in light of the importance of this. There, you got my unrequested opinion. Senator Kroon?
Thank you, Mr. Chair. And having grown up in a small business my entire life, owning a small business, I find it borderline insulting to suggest that small business owners aren't allowing their employees to go to the bathroom. I don't know what world you're living in, but that's just not a thing. And so $1,000 for a fine to flub it up a little bit, it doesn't mean they're being inhumane and not letting them leave a workstation or anything like that. But I just think it's excessive. And yeah, if this was the only thing that small business had to contend with, that would be one thing. But it's a cumulative effect again, as I mentioned before. But small business owners that I know are incredibly decent people. They're a tremendous asset to our communities. They employ a lot of people, and they're just not being treated fairly in this state. They can have options in all sorts of other states that appreciate their contribution to society more than the state of Minnesota seems to be these last few years.
Well, Senator Kroon, I have the same respect for small businesses that you have. And 99% of them, this won't be an issue. But for the ones for whom it is an issue, they need to have the incentive to come into compliance. And I will reemphasize, and you're a careful lawyer, you understand what the words "up to" means. They could be repeat offenders over and over and over again and still only be subject to a $1,000 fine for that day. If it didn't say, if it were an actual absolute $1,000 without the "up to" language, I'd be a little more on your side on this one. But I think it's appropriate to leave the commissioner have the discretion to tailor the fine to the circumstance, just like I do in our criminal statutes. That's why I don't like mandatory minimums. Any further discussion? Senator Umu Verbetten.
Thank you, Mr. Chair. I agree, and it's my understanding that under 14.045, agencies have like a number of criteria they need to look at, including willfulness, gravity of the violation, history of past violations, the number of violations, the economic benefit gained by this business potentially because of the violation. So all these factors in determining what that fine should be, and that's across the board for fines that agencies may impose. So I think there's some need for discretion, but there's also an outline of what they need to look at when determining what the right penalty should be.
Senator Howe.
Thank you, Mr. Chair. And I guess my question is there any funding or any plan to educate employers and especially the small employers that don't go to a lot of training and that type of thing? What is out there and what funding is in there to make sure that the training gets provided to these employers?
Commissioner Blissenbach.
Chair Latz and Senator, we have a number of people, staff within our labor standards unit where this law is enforced through that unit, whose primary job is to do education and outreach to employers across the state. We are in front of, I would say, on average, 20 to 50,000 different people talking about the laws that we enforce and helping to educate employers about their responsibilities under the laws that we enforce, as well as educating employees about the rights and responsibilities they have under the law that we enforce. So we have people that is their job, is to go out and do education and outreach.
Senator Howe.
Thank you, Mr. Chair. And Commissioner, is there going to be an update sent to every employer so they understand this? So that's my question really is there a plan to send this information out to employers, or are employers required to take some updated training? How exactly is this information? I understand you got people on staff to do it, but what's the plan to actually get this updated information out to those folks so they get an opportunity to implement it without somebody coming threatening them with a fine? So,
Commissioner Blissenbach.
Chair and Senator, yes, we do a lot of emails out to employers that have registered to receive our updates. We have a wage and hour bulletin that goes out quarterly that has, I believe it's somewhere around 60,000 recipients. We also offer webinars, and we publicize those webinars. We do those webinars after every legislative session to highlight any changes that have come under our jurisdiction. And then we have great partnerships with many of the business associations that exist, including the Chamber, including the Grocers Association, many different employer associations that we pair up with to do presentations.
Senator Howe.
And that's great. But there are, most of our small businessmen out there don't belong to a lot of associations. And that's my concern. And I think that's where my concern is that I don't see a plan to actually go out and identify those small businesses and push the information out. It seems like it goes out to the associations. There's a lot of staff time for webinars, that type of thing, but I don't see the push going to those small businesses like I am to actually find this, that it's pushed to them. It looks like they have to request to be on an information site. They have to go to a webinar. They have to do this. I think it's important that we push this information to employers to make sure that they have this out there and we don't miss them, because that's my fear is that they're not going to have the information, and that's where we're going to get caught. So I'd appreciate to see some type of a push of information out to those small employers and make sure that happens. Thank you, Mr. Chair.
Any other members of the committee have any discussion? Senator Westlin.
Mr. Chair, Commissioner, would this new requirement apply to the legislative bodies too?
I'm not sure if that's a rhetorical question, Senator Westrom.
No, it's as serious as I'm sitting there, Mr. Chair.
All right. Commissioner Blissenbach, do you have an answer?
Chair Latz and Senator, it would apply to anybody who is defined as an employee under I think it's Chapter 177. So I don't believe elected officials are covered, but it would apply to any employees who are staff that work for the Minnesota Senate or the Minnesota House or, any other state official.
Well, Mr. Chair, that's the answer I thought.
Senator Westrom.
But, Mr. Chair, and to the author, maybe we should clean up our own house before we decide to clean up everybody other's small business across the state. There's many, 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 many times, maybe another many, that this legislature goes way more than 2 or 4 hours, and we don't take breaks so everybody can have a bathroom break or a lunch break and not miss what's going on. For crying out loud, we didn't even allow water on the floor for staff up till this year, or legislators up to 2 years ago. And we're talking about this for all the small businesses, and this doesn't apply to us. I think we should clean up our own house first. Let's start with that and be an example. Mr. Chair, I think we should lay this over for an amendment and at least have it apply to us.
Any further discussion from members of the committee? Not seeing any. Senator Umover Benton moves that Senate File 2373 be recommended to pass and be re-referred to the Committee on Labor. All those in favor say aye. Aye. Opposed? No. Motion prevails. Thank you, Senator McEwen.
Thank you very much.
Senator Pappas. Senate File 2200.
Amanda? Yeah. Why don't you come join me? Mr. Chairman, if I could move the A2 amendment to put the bill in the shape I'd like it in.
Senator Pappas, this is the first stop for this bill. This will be
Yes.
considered an author's amendment, the A2. Senator Pappas moves adoption. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Pappas, tell us about your bill.
Thank you, Mr. Chairman. This is really a follow-up with the restorative practices bill that we passed in the past. And I just wanted to remind members that I became interested in restorative practices after attending Veterans Court with Senator Limmer and Senator Anderson a few years ago, who are also co-authors of this bill, and thank you very much for co-authoring. It was extremely emotional, as Senator Anderson and Senator Limmer probably recall, and we really saw how in the veterans community and in court, how everyone in the veterans community, including the courts, the criminal justice system, were all rooting for him, in most cases it was a him, and helping him to succeed and integrate back into civil society. And it's very similar in restorative practices, where the desire is to really get a meaningful accountability and to help offenders understand the real impact of their actions. So under this legislation, statements made in the context of a restorative practice setting would be inadmissible in court. The goal is to create a realistic space for victim-offender dialogue where the offender can accept responsibility for their actions without the possibility of their open, honest statements being used against them in another context. What this bill does not do is interfere with the traditional legal mechanisms for holding offenders accountable. Prosecutors can simultaneously or at a later date bring offenders to justice, regardless of whether the victim chooses to explore a restorative path to accountability. For more kind of background and information, Mr. Chairman, I really want to turn to my testifiers who really have lived experiences with restorative practices.
Thank you. And just to let you know, members, the plan here, apparently there's some additional amendments being worked on. So we're going to take the testimony today, especially from those who have traveled to be here. And then we're going to lay it over and we will revisit the bill on the merits on Friday.
Great.
So I'm not sure who's at the table, so
Ms.
who wants to go
Seeling.
first? Just go ahead and identify yourself and provide
Certainly.
us with your testimony.
Thank you. I appreciate you hearing the testimony today because I did drive from Yellow Medicine County, which is about 3 hours away. So I appreciate you hearing it today. My name is Amanda Seeling, and I spent almost 20 years practicing in one way or another in Yellow Medicine County. In my last 15 plus, I was an assistant county attorney in Yellow Medicine where I handled the juvenile prosecutions, the child protection prosecutions, and sexual assault prosecutions. Today I'm here to ask for your support for this bill for SF 2200. We have been using the practice of restorative practices in Yellow Medicine County for almost 25 years. We use a practice called Circle. Through the years of using Circle, we've seen significantly reduced numbers of out-of-home placement which then comes with associated out-of-home placement costs for taxpayers, as well as significant reductions in recidivism, while simultaneously holding offenders accountable for their actions. If a young person is charged with a crime in Yellow Medicine, they can be referred to Circle. This is just one of the ways that we do it in Yellow Medicine. In that process, a youth takes accountability for the harm that they caused and the people that they harmed. They agree to set a set of goals that they work towards in order to rebuild their place in the community. If they don't meet their goals, the case can be returned to the traditional court process. If they do, the case can be dismissed. One of the fundamental tenets of restorative practices is confidentiality. During the Circle process, people share their experiences through extremely vulnerable stories, which is why it's so important that we make guidelines that what happens in Circle stays in Circle. SF 2200 actually proposes that we back that up with legislation and we provide it legal protection, similar to what we do with ADR, which is another meaningful mediation process. The research is clear. When offenders take accountability for their actions, they are less likely to reoffend. When offenders take accountability for their actions, victims have a more successful healing process. Confidentiality, in this case, encourages accountability. So please support this bill. Thank you.
Thank you, Ms. Seeling. Appreciate your being here. Go ahead and identify yourself.
Yes, my name is Sarah Super, and I'm a volunteer advocate working on this bill. In 2015, I had an ex-boyfriend who broke into my apartment and raped me at knife point. He was arrested that night, successfully prosecuted in Ramsey County, and sentenced to 12 years in prison. He's part of the 3% of rapists who are ever held accountable for this crime. 97% of rapists walk free. With the validation of the court system, I had the freedom to tell my story publicly. And by doing so, I heard from more than 1,000 survivors from across Minnesota telling me their stories. In line with national statistics, less than half of them had chosen to report to police, and those that had almost never saw justice from the legal system. In 2017 through 2021, I helped advocate to eliminate the criminal statute of limitations for sex crimes in Minnesota, which we did successfully with bipartisan support. It gave survivors the important choice of reporting their experiences whenever, if ever, they wanted to. Today's survivors are asking for the option of having a restorative practice. And similar to the statute of limitations, even though you might file a report with police, it doesn't necessarily mean that you will see a conviction. If you seek a restorative practice, it doesn't necessarily mean you'll have a dialogue or get an apology, but having the choice is healing. I ask that you support Senate File 2200. Thank you.
Thank you, Ms. Super. Appreciate your stepping forward to share your story with us.
Kenosha here too.
She's not, but we have one more survivor who'd like to share.
All right. Thank you. Why don't you make room for her to come forward? Are you Ms. Weiss? Did I pronounce that
Yes.
properly?
Weiss.
Weiss. Thank you for
Hello.
being here. Go ahead and present
Good
yourself.
afternoon, Chair Latz and the committee. My name is Sandra Weiss. I'm an engaged community member, the daughter of a police officer, the owner of a successful restaurant in St. Paul, and a lifelong Minnesotan. As an adult in my 40s, I was attacked in the dark and raped by a known acquaintance. After the assault, I reported to the police and nothing happened. It's very challenging to charge someone for sexual assault, let alone convict them. Most victims are assaulted by someone they know. This makes it more challenging for victims to understand what just happened, and we can blame ourselves for someone else's crime. If we get a rape kit, it will only verify that we were in contact with another person. It does not differentiate, it does not differentiate consensual sex from an assault. When the burden of proof is not met, as it is in the case of 97% of the time, they say it's just a he said, she said situation, so nothing happens. Pardon me. Ideally, rapists would get charged, but they are not. Ideally, there would be They could be civilly sued, but they very rarely are. My experience with the legal system left me feeling worse than before I turned to the system for help. I have no doubt that I could have experienced a piece of the justice I desperately needed and wanted much, much sooner with the restorative practice had it been available to me. I urge you for support on this bill. Thank you.
Thank you, Ms. Weiss. Thank you for sharing your story with us here today. Senator Pappas, I get the impression that the restorative justice would be available to people even if the criminal process does not proceed toward formal prosecution or conviction. Is that correct?
I believe that's correct, Mr. Chairman.
So that would provide a sense of responsiveness and justice to the 97% of those who don't have any criminal prosecution following their case. Is that right?
Right.
That's right.
Did you have any other testifiers, Senator Pappas, at this time?
I do not.
We originally had Kenosha Alexander signed up, but she did have to excuse herself. But she wanted to speak on behalf of the Minnesota Coalition Against Sexual Assault, who's in support of this bill, as well as the other victim coalitions, Minnesota Alliance on Crime, Violence Free Minnesota, and the Minnesota Indian Women's Sexual Assault Coalition.
Thank you, Ms. Super. And there are letters in the committee packets as well. Let's open it up to committee discussion. Senator Westrom.
Mr. Chair, Senator Pappas or one of your testifiers, I'm trying to figure out for sure, how would this just apply to the 3% of people that are charged and convicted? But the discussion seems to indicate maybe the 97% would be more participatory in this process as well. And that's where my disconnect is. Is that, am I hearing that right? And if so, how would that apply to the 97% that are often not charged, or it's a he said, she said, and so they don't feel there's enough evidence? How would they get involved in this process, or am I misunderstanding?
Mr. Chairman, I think there are different approaches to restorative practices. I mentioned something in the veterans community. It can be youth that are involved. The Coalition Against Sexual Assault has talked about how it could be used in their circumstances. So there are just different circumstances. There's no kind of one circumstance.
Senator Westrom.
Mr. Chair and Senator Pappas, so would the prosecutors or police use this as an alternative, kind of like ADR was mentioned? Would they use this as an alternative? Do they feel at least some that maybe they don't have the evidence of, but there would be no, no use against a party if they do apologize or they do meet and confer and maybe resolve some issues that were causing a lot of harm or trouble? Is that, am I getting it?
Mr. Chairman,
Right.
I think
Senator
Professor Seeling has many years of experience with this, so I think she can address that.
Okay.
Thank you. Thank you. Essentially, I think the disconnect is really in the fact that restorative practices are used by a variety of counties in a variety of different ways. And so absolutely, if a jurisdiction has it available that a nonprofit or a community organization would be willing to take on essentially a mediation process between a victim and an uncharged offender, that could occur and it would be covered by the statute. Similarly, if somebody was charged and referred to a restorative practice, this statute would cover that restorative practice if it was a government referral, in addition to whether it was a privately arranged event between parties, more in that civil side, like ADR. But it also covers a variety of criminal prosecutions, and each jurisdiction does that just a little bit differently. And so that's why it's written the way that it is, to cover all of those circumstances.
Mr. Chairman and Senator Westlin, all this bill
Senator
really
Pappas.
doing is, thank you, is providing like some privacy some privacy protections to the participants.
So that's where I was going to go, Senator Pappas. The bill before us does not establish a new restorative justice program. The bill before us deals with the data that is involved, the communications, the conversations, and how that is being protected or available in any criminal prosecutions that may result as well. So if we could possibly focus any further discussion on the data bill that's before us, then we have a chance to get to the rest of the bills on this agenda.
Mr. Chair.
Senator Westrom, two of the
Just,
data
I think-
questions in the bill before us.
With all due respect, I think my questions are right on that point, because if making it confidential is going to incentivize or make it easier for the victim and the perpetrator to have this discussion, and the perpetrator knowing that what they discuss, much like ADR, is not going to be used as public information or in court, is that a big reason why we have this bill here, Senator Pappas, or to the witness?
Yes.
Senator Pappas.
Yes.
Okay. Senator Kroon.
Thank you, Mr. Chair. And this will get to the data practices part, but in lines 1.19 and 1.20, I see 4 different people that would be participants in this restorative practice. I understand who 2 of them are, the person who has caused harm and the person who has been harmed, but who are the facilitator? Who's the facilitator and who is the community member? Are they, I guess I'll ask a compound question. Who typically are these people, and are they members of a government entity? And if not, are they being paid?
Senator Pappas. Professor.
Thank you. So that partially depends on how and where the restorative practice is occurring. In Yellow Medicine County, we actually have a restorative justice department, so they are government employees who are facilitating the circle. But we have recruited heavily to the community for volunteers who then participate in helping that person reintegrate into the community. So in Yellow Medicine, the community members are not paid. The facilitator is, and we're working, we had a meeting this morning with Priya to make sure that it's clear that the government employees are public information, the people who are getting paid for their work. In Ramsey County, for example, those of you who aren't from outstate don't necessarily know how things work in outstate, but we don't have nonprofit organizations doing this work outstate, so it's government agencies that are doing it. Whereas in the metro, there are more nonprofit organizations that are being contracted with by counties to do some of this work. And so those folks generally have a facilitator who gets paid to do the work. And so they would have, that also would be public information, that paid facilitator. And then the community volunteers would be confidential.
Senator Kroon.
Thank you, Mr. Chair, and appreciate that answer. That's very helpful. I don't have an issue with confidentiality to certainly the person who's been harmed for sure, or the person who has caused harm, that's kind of part of it. And to a purely volunteer community member facilitator, I can understand it. But to me, if they're a government worker or if they're being paid, then they should be exempted out of this.
Yes. And that is an amendment that we're working on for Friday.
Professor.
Sorry, thank you.
I don't know.
Good suggestion, Senator Kroon.
Yeah, thank you, Mr. Chair.
Don't get too excited. That might be it for today.
Well, I think, Mr. Chair, if I could offer
Senator Kroon.
something as a suggestion to see if, I don't want to have to do this on the fly if they're uncomfortable doing that, but
No, this, as I said, this will be coming back before us on Friday. We're just going to lay it over today. So,
Okay.
Yeah, go ahead, make a suggestion. They can work on it in a couple,
Yeah,
in the next few days.
Thank you, Mr. Chair. Page 2, line 12. could say, this paragraph does not apply to any employee of a government entity as defined in section 13.02, subdivision 7A, or any other person who receives payment to participate in a restorative practice.
May I?
Professor Seelan.
Sorry, thank you. That is, we would like for the language to be government employees acting in the court, in the scope of their employment. And I think I would need to check with my cohort here in Ramsey and in Hennepin, because they do give their volunteers a small stipend for participating in circles, and I would exclude them from that language. So I think there's absolutely a need for the people who are doing the facilitation, who are getting paid and contracted with for the facilitation. I completely agree, and that was never the intent, to keep those names secret. And so I appreciate that as the proposed language, and it very closely matches what we discussed this morning.
Mr. Chair?
Senator Cron.
I'll reserve, we'll wait till Friday, that's fine. So you can talk to who you need to talk to and get the language exactly the way you want to get it. The other part of this, in line 126, it talks about how, where they may disclose some information, but does anything in this bill prohibit, say, the victim or the person who has been harmed from sharing their story in general, or is it just specifically what happens in that session?
Professor Seelan.
Thank you. It specifically prohibits from sharing what is happening. We don't have any power to take people's stories away from them, nor should we. It's very important that we all have our own stories. And so the victim can talk about their story wherever they need to talk about it, whether that's in therapy, whether it's at a public meeting. It does prevent them from talking about the things that happened in the restorative practice. So in that space, in that session, if somebody else said something that shouldn't be disclosed, that's the stories that we're trying to protect. Does that make sense?
Mr. Chair, real quick, and maybe this could be for Friday too, I'm struggling with the language that's in here, lining up exactly with the intent that you just laid out. So maybe that's another something to work on for Friday. Thank you.
Any further discussion? Senator Limmer.
Thank you. Real briefly, in these circles that you have, if the perpetrator would happen to say something about another victim, is that protected speech, or is someone in the circle a mandated reporter? Could you just tell me what happens in a situation like that?
Professor Seelan.
Thank you. Absolutely, that's a great question. And there is the exception for disclosure is necessary to prevent reasonably certain death, great bodily harm, or commission of a crime. So that language is in there if they're going to commit a crime. And it also, we always have, the additional language is mandated reporter statutes for both elder abuse and child abuse. Obviously, if anything gets disclosed, it has to be reported under the law. And nothing about this law changes that. Thank you. That's a great question.
Any further discussion? Not seeing any. Senate File 2200 is laid over. People can anticipate it'll come back on the agenda Friday. Thank you. Senator Westlin, Senate File 2328. Members, the intent is to lay this bill over for possible inclusion. Senator Westlin, if you go ahead and give us a brief summary of your bill, please.
Thank you, Mr. Chair. Thank you, committee members. I'd like to present to the committee for consideration Senate File 2328. Under the leadership of Sheriff Dewana Witt, the Hennepin County Sheriff's Office is making meaningful strides to strengthen public policy or public safety in both the short and long terms. One of the standout initiatives is the HOPE program. HOPE stands for Helping Others by Providing Education, which leverages time in custody to equip incarcerated people with critical skills, resources, and a renewed sense of purpose. Senate File 2328 is about ensuring the continued success and expansion of HOPE. This bill will provide necessary funding to retain a full-time teacher, secure licensing for essential educational materials on personal development and responsibility, and invest in key workforce training technology for careers in construction, electrical, and plumbing trades, all through 2027. These investments aren't just about education, they're about breaking cycles, improving safety within the facility, and giving people the tools they need to successfully reintegrate into our communities. And to share more about this program, Sheriff Dewana Witt is actually here to testify in more detail.
Sheriff Witt, welcome to the committee.
Good afternoon, everyone. Thank you. As you heard, my name is Dewana Witt. I'm the Hennepin County Sheriff. Thank you, Senator Westlin, for the great introduction. And thank you, Chair Latz and committee members for hearing me today. I have the privilege of working on the whole program since before we officially launched in 2021. From the start, our goal has been simple: to provide people in our custody with real opportunities that can better their lives, so that when they return to their communities, they have a better chance at success. The support provided by this bill will allow us to fully fund the equipment, teachers, and licensings needed to keep this program going through 2027. And I can tell you, the investment is worth every penny. The people in our communities, we owe it to the people in our communities to provide them with the opportunity to better themselves. We all know that staffing challenges in law enforcement are extensive, and that includes corrections. Programs like HOPE require additional staffing, but they also boost morale amongst our staff by fostering a more constructive environment. When our inmates have the opportunity to learn and grow, it improves safety inside our facility for everyone. Studies have shown the more programming in correctional settings has a direct impact on decreasing violence in those very settings. Jail time should not be wasted time. Here's the reality. The Hennepin County Jail is a pretrial facility. It's the largest jail in our state, the most populated jail in our state. 80% of our incarcerated population go back into their communities upon release. If we aren't preparing them to better their lives while they are in our custody, then we will be failing them and we will be failing our communities. Let me be clear. This program is not a replacement for accountability, but accountability alone isn't enough either. When paired with education and training, we can help people change the mindset and ensure that they don't come back through our doors. When we have people in our facility, we also have their attention and they're away from the stressors in their lives, whether it be mental health struggles, chemical health struggles, and things like that. Since we have launched the HOPE program, 282 people have completed our entire life skills program, and that includes things like parenting, employment, domestic violence prevention, cognitive awareness, and things of that nature. Since the program has been launched, over 1,500 individual certificates have been issued. Also, 633 individual referrals have been provided through our connector, which is a resource that we use with a local community-based organization that offers reentry services to individuals returning to their communities. And perhaps the most meaningful thing to me is that we regularly hear from people who have been incarcerated in our facility, as well as their family members, asking for either more resources or just to thank us for giving them that opportunity. In fact, we had one father come to our facility because he wanted proof that his son actually got his degree there. He didn't believe it. While our primary focus has been vocational and life skills training, we also provide an opportunity for those who want to not only earn their GEDs, but also a diploma. It is very important to have those resources available, again, because when they're in our facility, I have their attention. Jail time should not be wasted time. I'll close with this. I've worked in corrections for many years, Hennepin County, Ramsey County, and Dakota County. These types of programs are definitely needed in our correctional settings. But right now, it's more important than ever, because since 2019, the median length of stay in our jails has increased sharply. That means we have people in our custody for weeks, months, and can be years at times. We owe it to them and to the communities that they will return to provide them with the tools they need to succeed. We know that recidivism is an issue, but lack of education and cognitive training while incarcerated should not be a contributing factor to that. We must put focus on the educational and vocational needs of our incarcerated population, as they are also community members. Thank you again for your time, and I'm happy to answer any questions you may have of me.
Thank you. Sheriff, I understand this is an existing program that you have?
Yes, sir.
And how is it currently funded and at what level?
It's funded through our budget currently, and I think, as we all know, we're having some crucial talks in Hennepin County as well as budget too. This comes directly, again, from our budget. We made it work, it's been difficult. But again, when I think about the morale, when I think about the decrease in number of assaults within a facility, it's well worth it.
And what is the current level of funding for the program, Sheriff?
I do not have that right now in front of me, but one of the things I will tell you we had to do is we had to fund a full-time teacher, a licensed teacher, to do this program, and that takes the bulk of it, which is around $93,000 a year.
Okay, the intent's to lay this over, so before we come back to it, if you could please get to the committee information on the existing funding levels and how it's used, that would be helpful, since we're being asked to supplement an existing program.
And I think, Mr. Chair
Senator Westlin.
and Sheriff, I think it would be helpful too to know, I believe Hennepin County just announced a number of budget cuts they're going to have to make, and if that would impact your funding, and funding for this program would be helpful to know that as well.
To me, there's no doubt about the value of the program.
Mm-hmm.
The question is whether or not we're going to have the budget room to supplement local programs of this nature and in this amount. So, but thank you. Any further questions or discussion, members of the committee? Senator Westrom.
Mr. Chair, I guess a question following up on yours. So the county is funding this now, and the proposal here, Senator Westlin, is to have the state take this over for Hennepin County, but, and we're not, that'd be the only county that we're taking it over for.
Sheriff Witt.
We're asking for the funding to make sure that this program continues through 2027. Again, something I'd like to add is that this came out of my budget for the sheriff's office, so we had to make it happen. There are things like equipment that we applied for grants for, one-time grants to help supplement some of the equipment that we needed to use, including books or tablets and things like that. So it was piecemeal together, and it's been quite successful, and I think it's worth making sure it doesn't go away.
Senator Westrom.
Mr. Chair, Senator Westlin, do other counties do this already too, that you know of?
That is, thank you, sorry. That is a very good question. So I can tell you, the Hennepin County Sheriff's Office is part of the National Sheriff's Association. I learned about this program through the National Sheriff's Association. I sent our staff to Genesee County in Michigan to see how ours ran. They saw how successful it was there. Since we have launched it in Minnesota, we were the first sheriff's office to launch it. Now I can tell you Wright County has adopted it, Stearns County and Ramsey County, I believe, is about to launch theirs as well. Again, the success has been shown across the nation, and we were the first to launch it.
And so,
Senator Westrom.
Mr. Chair, Senator Westlin, if you know, do we fund any of these other counties? And how much are you asking for in this proposal again?
Senator Westlin.
Mr. Chair, I don't know if we fund any others, but this is a request for $92,000 for 2026 and $92,000 for 2027. So it's a fairly small amount of money.
Senator Westrom.
I'm
sorry.
Sorry, and
Sheriff Witt.
if I can add, those 3 counties all adopted it this year. We didn't ask for funding for the first years as we was putting it together, looking at the success rate of how it works. So I wouldn't think that those sheriffs have had the opportunity yet to do it, but they all launched just this year, 2024 and 2025.
So,
Senator
Mr. Chair, Sheriff,
Yes.
is this 92,000 what your whole program costs, or is this just a part of that expense that you're trying to get assistance with?
Sheriff Witt.
One of the biggest expenses is getting a teacher to teach this program. It has to be a licensed teacher to teach these programs, so that is the bulk of the cost. Again, we applied for grants for some of the equipment needs that we needed, including work simulators to teach technical skills, but the biggest cost to us is for staff.
And so, Mr. Chair,
Senator
the
Weston.
question again, Sheriff, is this cover your entire cost, or how much, is this just part of your program cost?
My apologies.
Sheriff
It does. I apologize to both of you. It covers most of it, sir.
It does. Okay. Last question, Mr. Chair.
Senator Westrom.
Sheriff, have you had any other opportunities from maybe nonprofit groups? There's a lot of good, well-intended nonprofit groups that try to help out in areas, and a lot of jail ministries through churches and other types of institutions. Do you have any opportunity for some of those groups that really want to try to help inmates improve their lives? I know in Minneapolis you've got some organizations that work with inmates getting out of jail and deconstructing homes and selling, repurposing materials that way, and it's a way they raise money. Is there any opportunity to partner with some of those groups that maybe would help or take on this opportunity to provide some educational classes, much like the mission of their group? Have you explored any of those options?
Sheriff Witt.
Yes, I can tell you, in fact, we have approximately 160 people that volunteer to work at the Hennepin County Jail. With every volunteer, it also causes security issues, as we also have to have deputies that are with those persons. Now, again, with the volunteers teaching our life skills, that's not a part of that bulk. That bulk of that money is for the licensed teacher to teach the educational courses, which is what is required by our state statute. But we do have volunteers to help supplement with the life skills and the spiritual, chemical health. We have a lot of programs that are being offered that are not a part of this. They're a part of the entire program, which is the HOPE program, to have a holistic approach in helping the people that are in our care.
And Mr. Chair and Senator Westrom.
Senator Westlin.
Just to clarify too, so the parts that would require a licensed teacher, they offer high school and GED teaching. They have financial literacy, trade skills training, employment prep, and there are certain things that would have to be, as Sheriff Witt indicated, that have to be provided by a licensed teacher. And while there may be ways to provide other supports for inmates, this is a very specific program that is really designed to provide very specific skills, education, GED, high school diploma, et cetera, employment training, financial literacy, et cetera, that are specifically designed to help someone return to their community and be successful in a way that perhaps they have not been in the past.
Mr. Chair.
Senator Westrom, last question, please. We have Senate limit
I just got a
waiting, and we
comment.
got 4 other bills to hear in the next 15
The last
minutes.
question's over, but Senator Westlin
Thank you.
perked the thought. And Senator Westlin, it's striking me that why don't our school districts, through their alternative education programs and alternative GED programs that they're running already with teachers, why wouldn't they be doing a part of this? I'm guessing in Hennepin County, you have a critical mass that's big enough to be some of the students that they're trying to reach out and offer alternative programming to. But is there a reason that the school districts aren't? And just a comment, but you can answer it if you have any thoughts on it. But otherwise, it's something maybe we should be looking at.
Senator Latz.
Sounds like an unfunded mandate on our school district, Senator Westlin.
Senator, can I?
Hold on, Mr.
Senator
Chair.
Westlin. I'm
I don't want
joking,
the
Senator
little
Westlin.
snippy comment like that, because Mr. Chair, the state spends a lot of money to educate students. That's the purpose of our school districts. So if they're already operating
Senator
it,
Westlin, do
I'm
you have
just
a
wondering
response
if we
before?
have a way to connect these dots with the money we're already spending.
Senator Latz and
Senator Westlin.
Senator Westrom, I'm assuming because this is happening within the jail and within the facility itself, and they are hiring a teacher to come and perform this service in the jail. I don't know that our teachers in our school districts necessarily signed up to go do work in the jail, but perhaps the sheriff has some additional thoughts on that.
Sheriff Witt.
Prior to having the whole program, we did have part-time teachers that were coming into the jail to help with this. That was not sustainable, as there is also a demand for teachers in our schools. Also, I think it needs to be clear, we are talking about adults, we're not talking about people that are of juvenile age, so there's not that opportunity for them to do that there. And as the steward of public safety for Hennepin County, it's my job to make sure that we're keeping people safe, holding them accountable, so bringing those resources to them while they are incarcerated in our facility has to be the priority.
Senator Limmer.
Thank you, Mr. Chair. If people haven't noticed, I'm a co-author on this bill, and I fully endorse this effort. When you consider the degree of crime that happens in the state of Minnesota, compare that with the crime in Hennepin County alone, I've been told that it's roughly about 50% of all the crime in the state happens in Hennepin County. The jail system in Hennepin County is larger than you would ever believe if you're comparing it to any rural county. It takes in all walks of life, and quite honestly, there's a number of people that have somehow slipped through the cracks of the public education system. My experience working at Hennepin County's workhouse over earlier years in my life realized that individuals who have a sincere desire to earn a GED comes out with a different perspective than they've ever had before. Somehow they fell through the cracks, somehow they don't fit in, and this is one step closer to getting them to be contributing members of society. They're in trouble with the law at the current time, but it gives them a little different perspective. And quite honestly, $93,000 compared to the whole state budget, in light of that huge proportion of criminal activity that happens in Hennepin County, I think it's just plain worth it. Thank you, Mr. Chair.
There not being anyone else on my list for conversation at this time, Senate File 2328 is laid over for possible inclusion.
Thank you, Mr. Chair.
Thank you.
And if Mr. Chair and Senator Limmer, I actually meant to
Senator
mention that
Westlin.
you were on the bill, and I apologize. But thank you for being a co-author.
Senator Westlin, how long do you think Senate File 2146 is going to take? I'm just trying to manage the agenda here.
Well, that depends on the committee, Mr. Chair.
Well, you have two testifiers here, and the plan is to lay it
They
over.
should be brief.
All right, we'll bring Senate File 2146 before the committee.
Okay, great. All right.
Senator Westlin, why don't you go ahead and describe the bill while it's being passed out to the committee?
Thank you, Mr. Chair. This is Senate File 2146. I will note on the top of the presentation that this is also a bipartisan bill, and I want to thank Senator Utke and Senator McQuaid for joining as co-authors on this bill. In 2024, the Federal Trade Commission reported that approximately $12.1 billion was lost to scams in the United States, and that would be a 25% increase in funds lost to scams. These scammers prey on vulnerable adults in particular through sophisticated impersonation, through romance, and investment scams. Senate File 2146 attempts to stop the bleeding from these scams by providing immediate injunctive relief by freezing assets when a vulnerable adult is exploited. Without that immediate action, the funds scammed from vulnerable adults are typically gone, and recovering those funds is very difficult. Subdivision 2, just do a very brief walkthrough, Mr. Chair, and then I'll turn it over to my testifiers. Excuse me, Subdivision 2 permits a petitioner to petition the court for an order for protection against financial exploitation of a vulnerable adult and any other equitable remedy the court deems just. The petition may be filed in the county where the petitioner, the respondent, or vulnerable adult resides. In Subdivision 4, requires the court to hold a hearing within 14 days of receiving the petition. Subdivision 8 lists when a court may issue a temporary ex parte order. An ex parte order is an order that is issued by the court before they have heard from the responding party. Subdivision 9 lists when the court may issue the order for protection. Subdivision 13 lists enhanceable criminal penalties for a violation of an order. And just for some clarification, this process actually very closely follows the order for protection process that is used in cases of domestic violence. However, under the current order for protection law, this type of situation would not qualify for an order for protection under existing law. And with that, Mr. Chair, I do have two testifiers, Jill Sauber and Victoria Larson, and I think we'll start with Ms. Sauber.
Before we do that, members, we are going to go past our 2:30 ending time here. We're going to try to get to some of the other bills here because there are people who have traveled from out of the metro area. So I'm doing the best I can to make sure we treat each bill fairly and the testifiers who've come here fairly, understanding that many of these bills being laid over are going to be back before this committee for further discussion, potentially as part of an omnibus bill. So Ms. Sauber.
Thank you.
Go ahead, please.
Good afternoon. Thank you, Senator Westlin, Chair and committee members. My name is Jill Sauber. I am a certified elder law attorney. I practice in Edina, Bloomington. I'm basically a solo practitioner practicing in solely the area of elder law. I also happen to be an acting commissioner with the American Bar Association Commission on Law and Aging, and I deal with financial exploitation and elder abuse and fraud in my practice. I will tell you, at least anecdotally, I see an increase in intake calls from people related to financial exploitation and abuse, and it continues to grow. I'm a one-person shop, and I have a pretty good idea of what's coming in the door, and I'm seeing a lot more of these cases. The intake calls come from family members, friends, loved ones of somebody who's the victim of exploitation, and sometimes even from the victim themselves. So victims of exploitation or elder abuse are often embarrassed to come forward to admit that they've been scammed, especially if it's a loved one or close friend that's scammed them. They're hesitant to report the scam, and they're reluctant to file a petition to maybe seek recovery or take action themselves. Sometimes they're worried about their physical safety in addition to their finances, and other times they just don't want to hold that alleged perpetrator accountable because they are that close friend or loved one, and sometimes they're even a caregiver for this individual. There's been a national and even international increase in these scams, and people are taking advantage of victims now more through social media. I'm seeing a lot more in my practice romance scams, people getting approached on Facebook, Snapchat, Instagram, of all ages, adults with disabilities or vulnerable adults, and they're getting scammed by people they've never met before. We don't always know who the scammer actually is, and I think that's increasingly more common. We don't know where they live. They could be in the U.S., they could be in the state, they could be outside of the United States. There is a provision, rather, in this injunction statute, the proposed law, that would allow us to serve some of these scammers that are unascertainable So if we don't know who the actual person is, where they live, we can't normally provide notice of any sort of proceedings. This would allow us to serve the scammer in the same method in which they're using to scam the victim. And that's huge. For instance, if we don't know who the scammer is and they are texting the victim or they're messaging them on Facebook, this bill would allow us to serve notice of the petition for financial exploitation injunction through the same means or method in which they are scamming the individual. Right now, without this injunction in place, the only method to protect a victim of abuse or financial exploitation is to seek either a protective order in court, civil probate court, or seek an emergency guardianship or conservatorship. Usually conservatorship here in Minnesota if they're being financially exploited. That is time-consuming, it is expensive, it is extremely stressful for not only the victim but also family members. And because it takes several days after you file a petition, even for an emergency conservatorship, to actually get in and get a hearing and maybe get an order in lieu of an ex parte order, there's time for that perpetrator to take the money and run. And the money's usually out the door. The transactions happen, the scam has taken place. So the current procedure allows us to stop the bleeding, stop the scam only after a conservator is actually appointed and we get that court order, and when the conservator has actual access to freeze those bank accounts. There's a huge lag in time. Even those days means that the money's gone. So this injunction would allow us to stop the bleeding right away, get in, freeze the assets before the transaction maybe even takes place, or reverse it immediately. The only other state that has a similar financial exploitation injunction is the state of Florida, at least that I'm aware of. I have a colleague, attorney Shannon Miller, who was involved as a president of the elder law section of their state bar, and they passed this legislation, I believe, a few years ago. After enacting that statute, Florida actually also prepared a judicial handbook to train and educate judges, and they produced the injunction form to provide on their judicial website to make it easy for people to access, file, and then the bench was educated on how this is going to look going forward. Preparing a similar judicial handbook or education piece and draft that injunction form to be readily available. And I offer up my own personal time to assist with that if this law does pass. I want to pass it off to the other testifier today. It actually is my client's daughter, Victoria Larson. She's here to talk about the case involving her mother, Barbara Casey, who was scammed. She'll explain how this injunction would have possibly prevented the ongoing scam from happening. It would have stopped the bleeding in that case, and it would have allowed us to avoid a very expensive and time-consuming emergency conservatorship altogether. So I will close with, I ask that you please support this financial exploitation injunction bill. This injunction will not only lessen the burden associated with emergency litigation to stop scams from happening, but it will also protect our vulnerable adult population. So thank you.
Thank you, Ms. Sauber. Ms. Larson, welcome to the committee. If you, I appreciate your being here and staying here for the whole afternoon here, but if you could please be as succinct as you're comfortable in providing your information, I'd appreciate it.
You got it.
Go ahead.
Thank you, Mr. Chairman, committee. I obviously am speaking in support of this. My name is Vicki Larson. February 27th, 2022, it started with a friend request on Facebook. My mom, Barbara Casey, deeply lonely, depressed. And then the first of 3 different men, all named Joseph Gary, befriended her. By March 21st, Mom decided she was divorcing Dad to marry this man, a man who was stuck in Syria, waiting for enough money to fly home on a private plane, a portion of which Mom had already financed, and then was calling all of us to help get the rest. He was also someone who promised to come to her, and thankfully never did. That same week, we initiated contact with an attorney, found Jill, and began the process of requesting an emergency guardianship and conservatorship. a process that all told took us until June to get in place. This meant Mom going from being scammed for a few $1,000s in March for this private plane to approximately $40,000 by the time we were able to get to court and successfully get everything in place by June 17th. And our family, I look back, was lucky in so many ways. We were lucky Mom told us about this friend early on. Lucky she hadn't withdrawn her annuity yet. Thankfully, they knew about this and they listened to us without the conservatorship in place. We were lucky she sort of listened to us when we attempted several interventions, slowed down the outflow of cash, at least for a short period of time. We were lucky it wasn't the stress from the scam that killed her. I have not been shy talking to people about our family's experience. Almost every time I get a response that they know someone too. Most recently, it was an acquaintance's mother who last year lost everything and maxed out her credit cards within a month, and that stress killed her. I wish I wasn't here to tell this story. I never thought this could have happened to someone so smart and often so cynical as my mother. I appreciate the work that's being done through this proposed legislation to protect others who will find themselves in a bad position just because they were trying to help someone, just because they wanted to be loved. Thank you.
Thank you, Ms. Larson, and for sharing your story with us today. Appreciate it. Senator Westlin, was there anyone else you wanted to testify in connection with this bill?
No, Mr. Chair.
Is there any discussion or comments from members of the committee? Senator Westlin.
Mr. Chair, Senator Westlin and testifiers, thank you for your comment. I'm wondering, just to get a little more context with your mother's situation, and I don't know the best way to ask this, so I'm just trying to be mindful, and I don't want you to answer anything you don't feel comfortable. But I'll tell you reason I'm asking it first, just so you understand. Were you concerned that she was maybe being taken advantage of with some cognitive decline and concerns that maybe don't rise to the level of dementia, Alzheimer's, et cetera, but was that a factor in this? And feel free to answer as you feel comfortable. Or was it that she was being scammed and she, purportedly has full cognitive capabilities? And the reason I ask that is it gets to be trickier if there's not cognitive decline. To where do you decide to draw the line of letting mom or dad make their decisions, even if it's a bad decision or scammed? And scammed, I don't think anybody wants to support, but when do we let somebody else, a third party, typically a child, step in and stop mom and dad from making those independent financial decisions? I'm aware of multiple situations where family dynamics just get to be tricky because mom and dad are supporting, let's just say, son or daughter X, and other son and daughter X and Y's don't think that that's a good place for them to go, and they think it might be a bad or a vulnerable exploitation, but it's a family dynamic, and mom and dad maybe do it because they know something different or whatever the reason is. And so, do you see where I'm going with my question? I'm just trying to, how do we draw the line here? And Senator Westlin, I welcome your thoughts on this as well, because I think the intent of this proposal makes a lot of sense, but in your situation, were there some other dynamics that also make this a vulnerable adult situation that was easier to scam?
Senator Westlin.
So, Mr. Chair and Senator Westrom, and then Ms. Larson can answer your specific question, but just to be very clear, this bill is specifically targeted at protecting vulnerable adults, and that's as defined in 626.5572. Vulnerable adult in that statute means any person 18 years or older who's a resident of or inpatient of a facility, et cetera, including somebody regardless of residence who possesses a physical or mental infirmity, et cetera. So this is specifically designed to protect people who meet the definition of a vulnerable adult. And with that, Ms. Larson can answer your specific question about her situation.
Senator Westlin, just before that, to supplement your response, lines 3.24 to .26 identify two of the factors for the court to consider as the capacity of the vulnerable adult to make decisions related to their finances and property, and the susceptibility of the vulnerable adult to undue influence.
Yes.
Ms. Larson, do you have anything to add?
Yep. In my mom's case, we did go through cognitive testing. We didn't, we knew there had been some decline, but in this whole process, trying to figure out where things were, her mental status, nothing was ever definitively, we knew there was decline, but nothing that was really diagnosable based on her test results. We did everything we could to try to figure out how to handle this, how to protect her. So, does that answer it directly enough?
Yeah, I
Senator
think so.
Westrom.
I think so. And Mr. Chair and Ms. Larson, that gets to be just where it's tricky. And in her case, it sounds like it wasn't a unnecessarily clear line either. I've got a case in my district, a story of some people that I know fairly well that have gone through this in the last 12 months, and their dad keeps going down to the bank and getting $500 withdrawals for this calls that he gets or texts on his cell phone. And the long story short, it's the same situation going on. He's losing $500 at a time, and they've finally now taken his phone away, and he's moved into an assisted living, but he was driving and going up to the bank, and the bank was calling the son in this case and saying, we just think this is not looking right, but he says he's got somebody he needs to pay this because he's won something, and I don't know. These are just tough deals because in that case, they needed to stop it as well. But, you know, there is family dynamics that also go on, and one sibling may use this nefariously to try to stop another sibling who maybe rightfully has financial payments coming from mom or dad for some other reason of working on the farm or other things, and somebody's mad or jealous. So that's where I just, I guess we got to rely on the courts some, but all of these things get a little tricky because where do you let people make their own decisions, even if it's a bad decision in some people's mind. But in this case, I don't think sending money over to Syria to somebody is ever a good thing, but I'm glad you were able to intervene, but if we can make it easier, it does make sense.
Members, just want to call to your attention the relief sections in subdivision 9 on page 4. And also the criminal penalty provisions for violating any order that's issued in this case, which appear to mirror the domestic violence order for protection criminal provisions as well. With that, not seeing anyone else appearing to wish to comment on behalf of the committee discussion, Senate File 2146 is laid over for possible inclusion.
Thank you. Thank you. Thank you, Chair. Thank you, members.
All right, we're going to do Senate File 2308, Senator Howe. And then after that, members, we're going to take up Senator Hauschild's bill, Senate File 2530, and that will conclude the agenda for today.
untimely phone call.
Senator Howe, I'm going to ask you to give us a brief description of Senate File 2308. We just want to make sure we had time for your testifiers to be here, to testify, especially the one from Meeker County who came here to.
We greatly appreciate that, Mr. Chair. And
Senator
Senate
Howe.
File 2308 is a grant program for the radio systems that are compatible with AMR. It's $2 million a year, one-time appropriation for 26 and 27. You know how I feel. I've mentioned it often, for our law enforcement and our public safety folks be able to communicate with one another. I will not belabor the point, and I'll just go to my testifiers and let them expound on that.
Mr. Schmidt?
Thank
Meeker
you.
County.
Thank you, Chair Latz, members of the committee, Senator Howe. My name is Steve Schmidt. I'm a Meeker County Commissioner, and I serve as the Association of Minnesota Counties. I'm on the executive committee. I was passed most recently Public Safety Policy Chair for the association, and I'm proud to support Senate File 2308, which proposes funding for grants to purchase or upgrade equipment for the Allied Radio Matrix for Emergency Response, or the ARMOR radio system. The ARMOR system is utilized in Minnesota's law enforcement, fire service, emergency medical personnel, and other public safety officials. The interoperability of the system is vital to coordinating responses to incidents and ensuring public safety and saving lives. I also serve as the Assistant Rescue Chief for the City of Eden Valley, and I'm the past. More recently, I was the Emergency Management Director for the city. I also am the Vice Chair of Central Minnesota Emergency Services Board. And one thing I want to point out about these radio systems, the current ones that we're using, they're fine when I want to talk to other members of my group, of our departments. But as we start layering these communication systems, you start putting LifeLink in the air, ambulance services, and as we layer these departments and agencies, it becomes more and more difficult for us to communicate effectively and cause a lot of problems. Despite its foundational role in public safety, the ARMOR system faces significant challenges due to aging equipment. Many local agencies are operating with first or second generation ARMOR radios that lack modern features. These outdated devices hinder effective communication and pose safety risks for both the responders and the public. For many local governments, especially in rural areas, securing the necessary funds to upgrade these is significant financial burden. Additionally, the Minnesota Emergency Communication Networks published a comprehensive assessment back in 2020 on the ARMOR system, which highlighted concerns about the long-term sustainment of the network. The report emphasized the need for detailed asset inventories and replacement plans for components that are not covered under current support agreements. The passage of Senate File 2308 will have a significant impact on public safety across Minnesota. The ability for counties to upgrade equipment will ensure that all responders can communicate effectively, reducing response times and improving coordination during emergencies. The grant program proposed provides much-needed financial assistance to local governments and tribal entities, particularly those in rural areas, ensuring that all communities have access to modern communication tools. By facilitating the replacement of outdated equipment, the Senate File 2308 supports the long-term sustainability and reliability of the ARMOR system. The Association of Minnesota Counties strongly supports House File 2308. We believe the bill represents a critical investment in our state's public safety infrastructure and ensures that our first responders have the tools they need to protect and serve our communities effectively. We urge the committee to support Senate File 2308 and recommend its passage by the full legislature. I thank you for your attention, and I stand for any questions.
Thank you, Commissioner Schmidt. Ms. Roard, if you have anything to add that hasn't already been put on the record, we'd like to hear from you.
Yes, thank you, Mr. Chair, members. My name is Jill Roard. I'm the Executive Director of the Metropolitan Emergency Services Board. We are one of 7 regional emergency communications or emergency services boards across the state. I won't belabor my testimony. I will just note that in addition to aging equipment, we are experiencing outside factors that are requiring some upgrades and/or equipment purchases perhaps earlier than were planned. The FBI's Criminal Justice Information Service is now requiring that any data that is considered criminal justice information be transmitted via the highest encryption possible, which is also, of course, the most expensive encryption possible. So that is creating some issues for local governments, not only having to replace aging equipment, but perhaps equipment that wasn't quite ready to be replaced. And I will just close with any amount of assistance would be helpful to local governments. We have some major, as Commissioner Schmidt alluded to, we have some major equipment that needs to be replaced in the next 10 years or so with a very high price tag. So any assistance would help local governments. Thank you.
Thank you, Ms. Roart. And as this committee knows, this is an ongoing funding issue, has been for years. Still working on trying to find a long-term funding source for this. Until we get some political consensus on what that might be, we're going to be left lurching from year to year with grant program requests, either directed to individual counties or like this to a statewide grant fund to be allocated by the commissioner. So we'll open up for committee discussion, but I think members can fairly assume that we all know the value of armor and the financial need that's out there and the expense involved. Any discussion? Senator Anderson.
Thank you, Mr. Chair. Thank you, Senator, for bringing forward this bill. If I take and look at the bill and it talks about local units of government and federally recognized tribal entities, and then if I divide that $2 million by all of them, you're just putting a Band-Aid. But I appreciate it, and I thank you for bringing the bill.
Mr. Chair.
Senator Howe.
To expound on that, on the last grant round that we had, 178 applications for $23 million in requests. Out of that, 77 were funded for an average of $51,000 apiece. Like you say, it's a Band-Aid to the $23 million requests that were out there for the last $4 million. So it is a need. I agree we have to find a long-term solution, but in the meantime, this is invaluable money for those small departments and for those law enforcement that now have to upgrade their system. So we have to continue to put the Band-Aid on or we're going to bleed to death.
Senator Anderson, Senator Howe, all those members who are here on a bipartisan basis, if you can find a fee somewhere in our system that you would support to increase a little bit to provide a long-term funding stream for this, rather than pulling money out of the general fund for small grant programs, I'm all ears. Anyone else have any comments? I don't see any hands going up with better ideas right now, Senator Howe. But my door is open for anyone who wants to step forward, anyone listening or watching this committee hearing as well as serving on it. With that, thank you, Senator Howe. Senate File 2308 is laid over for possible inclusion in the omnibus bill.
Thank you, Mr. Chair.
Thank you. All right, members, we are, as I already noted, we're not going to hear Senate File 1907. Today, we just are running out of time for this room and for committee schedule. But we will do our best to hear that early on Friday morning's committee hearing so that whoever was coming to testify doesn't have to wait around or guess when we might be heard or when they might be heard on Friday. The last bill on the agenda then for today is Senate File 2530. Senator Hauschild, thank you for waiting around today. Why don't you come on forward? Members, we did begin hearing this bill and we're going to return to it now. The intent is for this bill to be passed and re-referred to state. Chuck, can you give us a brief recap? And then, members, we have very limited jurisdiction in this bill. If you look on page 22, 26, and 40, the sections begin where we have jurisdiction. Senator Hauschild.
Thank you, Mr. Chair and members. During the last committee, we went through all the sections. We have talked about them. And during the last hearing, it was suggested by a stakeholder group that we remove the commissioner finds that on line 23.28 and also add tribal to line 22.31. Mr. Chair, we've received feedback from nonpartisan staff, I know that the DNR has done some looking into this, and then I've also talked to other stakeholders. And Mr. Chair, I would be happy to bring up the DNR if you would like to get their perspective, or perhaps hear from council on their findings on this and the impact it would have, if that works for you, or I can just express my concerns with this, which is I think it sets a bad precedent. I think we have this in here for a reason, to provide discretion to the commissioner on contested case hearings. There's ample opportunities for stakeholders to submit evidence and any data and information they need through that process. And, I think the DNR would back that up as well, but we can hear directly from them if you would like.
So first, I think we ended the last hearing with my question about what standard of review the Court of Appeals has when a DNR decision is made and appealed to the court. I know Ms. Primo has looked into that question. I'll ask Ms. Primo to give us a response to that question. Ms. Primo.
Mr. Chair and members, I also sent an email out to the committee members and the bill author as well, detailing some of this. Section 14.69 would be a starting point, and it lays out specific standards that would guide the court on appeal regarding when the court may affirm, deny, or reverse, or otherwise modify the agency's decision. And with respect to the specific issue raised by the testifier, as well as the case that was mentioned, that in part, the court looked at the specific, at the substantial evidence standard. And under that standard, the court looks at the entire record as it was submitted to determine whether the agency's decision is supported by that substantial evidence. If there are any specific questions, I'm happy to clarify.
Any specific questions from members of the committee regarding clarifying that legal question? I'm not seeing any. Is there anyone in the room that wished to testify specifically on the two questions that were really left before this committee? The one that was raised about potentially deleting some language on line 23.28, and one that was raised for the other provisions, inserting a reference to tribal participation itemized in the statute. I'm not seeing any right now. Members, I'm just going to state I'm sympathetic to the desire to have robust commissioner basis for making decisions and a robust opportunity for those who disagree or who wish to make a record to have hearings and present evidence. I'm a little uncomfortable. I'm a lot uncomfortable with the notion of making what would in effect be a very substantial change in existing practice, not only as proposed for this statute, but also in a lot of other commissioner actions, I think not even specifically in the DNR, but also in other agencies. without having really a broader and full-throated conversation about that in the broader context. So my personal inclination, despite my concerns about outcomes that could be of concern, I'm inclined not to make any changes in the bill here today. And if anyone wishes to have that broader discussion on the topic, I would recommend introducing a bill to that effect. And since the topic will bring it to this committee, we could use that as an opportunity to have a broader conversation. So that's my own inclination, but of course, it's the committee's decision how to proceed here today. So is there any further discussion? Anyone want to comment on any of the topics before this committee before we consider the proposal to move this on to state and local government? Senator Westlin.
Mr. Chair, I think I would concur with your sentiments, Senator Hauschild. Is that your desire as well as the author, trying to move this bill forward for capturing this potential opportunity?
Senator Hauschild.
Mr. Chair, Senator Westrom, yes, that is my position as well. I concur with the chair.
Mr. Chair, I urge our support of this bill.
Is there any further discussion from members of the committee? Senator Westrom, since you spoke up, is it your desire to make the motion on this?
Mr. Chair, I will move this bill, and you can fill in the details on the motion, where it goes.
Senator Westrom moves that Senate File 2530 be recommended to pass and be referred to the Senate Committee on State and Local Government. All those in favor say aye. Aye. Opposed? Motion prevails. Members, thank you for your robust work today. One more announcement. We will reconvene in Minnesota Senate Building, room 1200 on Friday at 9 a.m. Members, we have 30, 40 bills, something like that on the agenda. Feels like we're getting toward deadline week. So plan for lunch and probably dinner on Friday. I'm sorry we have to do this, but
Is that with bathroom breaks or without bathroom breaks?
I have a method already prepared to cover the clock if we need to. With that stated, we are adjourned.